Senator John Kennedy had one question, and it took 4 words to ask. A civil rights lawyer with a Supreme Court argument on his resume sat 12 feet away and could not say it. Not wouldn't, could not. The setting was a Senate Judiciary hearing on the most consequential voting case in a decade, and Kennedy kept the entire thing down to a single sentence a child could follow. You're going to hear that sentence in the back half of this video, along with the 2 words the lawyer used to dodge it, and the 4 words Kennedy used in reply. There is a Supreme Court ruling at the center of this, decided 6-3 about a month earlier. And there is one question every witness at that table was asked, where 2 of them answered in a single breath and 1 of them went quiet. The hearing was the Senate Judiciary Committee's first response to Louisiana versus Callais. On April 29, 2026, the Supreme Court had ruled 6-3 in an opinion written by Justice Samuel Alito that a second black majority congressional district in Louisiana was an unconstitutional racial gerrymander. The decision raised the bar for proving racial motive in redistricting and narrowing how Section 2 of the Voting Rights Act could be used to challenge a map. Republicans called it a return to the Constitution. Democrats called it the kneecapping of a law passed in 1965. Both sides agreed on one point. It would redraw the political map across the South before the midterms. 3 lawyers sat at the witness table. Edward Grime had argued the Callais case itself. Will Chamberlain was senior counsel for a conservative legal group, and Todd Cox was a civil rights lawyer from the Legal Defense Fund, the organization Thurgood Marshall built. Cox was, by every measure in that room, the most credentialed defender of the old voting rights regime on the panel. Kennedy turned to him knowing exactly that. He did not want a lecture. He wanted a yes or a no. Here is where the room learned what Kennedy was doing. He did not open with an accusation, he opened with flattery, which is the most dangerous thing a Louisiana lawyer can hand you. "You're smart," he kept saying. "You're all smart. I'm just trying to get to the bottom line." He turned first to Grime, the man who had won the case, and walked him through a plain English version of the ruling. "Colleges," the court had said, we are not going to run your admissions office, but you cannot use race as a factor. Same logic," Kennedy said, "for drawing a district. Is that what the court did, or am I misunderstanding?" Grime told him he had it basically right. Then Kennedy turned to Cox and asked him to confirm it. That was the trap, and it was a quiet one, because Cox could not simply say yes. Saying yes would concede the whole hearing. So instead, he reached for the thing lawyers reach for when the plain answer hurts. He started to explain. He started in on Robinson, on Section 2 findings, on the procedural history of how the district came to exist. And Kennedy, who had been a lawyer himself, recognized the move on sight. "Don't muddy the water to make it look deep," Kennedy told him. The line drew the first laugh. But watch what it was actually doing, because this is the part the clip's title leaves out. Every time Cox answered with another paragraph, Kennedy narrowed the question further. He went from the case to the holding to a single sentence to a single word. "You're speaking like a lawyer," he said, "and this is not a common law class." He was sending the question down until there was nothing left to hide behind. Then he set up the real one. He told Cox he was going to put it another way, and the way he chose was so simple it sounded almost naive. He let it sit. "Do you think race should be used to harm a person?" 2 questions, 14 words, no statute cited, no precedent named. The kind of thing you could ask across a kitchen table. Kennedy asked the civil rights lawyer first, and then he asked the other 2 men at the table the exact same thing, because he already knew their answers would not match. Before the answers came, Kennedy did something that mattered more than the question. He told Cox he understood. "I've been where you've been," he said. "When you get in front of a court of appeals and you're losing, you want to obfuscate. I get it." It was the cruelest kind of mercy an experienced trial lawyer telling a younger one that he could see the evasion for exactly what it was. Cox tried to reframe. He argued that a co-equal branch of government, Congress, could look at Callais and decide the court got it wrong, the way Congress once answered an older voting case. It was a real argument. It was also in that moment a man reaching for the seal squealing because the floor had been taken out from under him. Kennedy let him finish and came back to the same two questions, slower this time. Stay with this because what separates the next 60 seconds from an ordinary hearing is not what Kennedy says. It is what three different men do with one identical question. Two of them answer it in a single word. One of them does not. And the gap between those reactions is the whole reason a redistricting hearing ended up with millions of views. Do you think race should be used to help a person? Kennedy asked Cox. I don't understand that question, Cox said. Kennedy asked again. Do you think race should be used to harm a person? I don't really understand what that question, Cox started, and he could not finish it. No, Kennedy said. I didn't think you would. 4 words, no heat in them. He had not raised his voice once. Then he returned to Chamberlain. Is it fair in America to use race to help a person at the expense of other races? No. Is it fair to use race to hurt another person? No. He turned to Grime, the man who won the case. Race should not be used to help or hurt an individual, Grime said. Absolutely not. 3 lawyers, 1 question. 2 of them answered before Kennedy finished asking. The third had a Supreme Court argument on his record and could not say a word a child says 100 times a day. After Kennedy yielded, the gavel passed to Senator Whitehouse, and the hearing rolled on as if nothing had happened. Cox never got to land the answer he wanted. The Callais ruling still stands. Across Louisiana, the 2nd district that sent a black congressman to Washington is living on borrowed time, and the map that replaces it is being drawn now, before the midterms, by people who watched this exact hearing. Somewhere in that state, a voter who has cast a ballot in that district for 20 years has no idea the lines are about to move. Here is what is worth keeping. Kennedy never argued the law. He asked a man whether race should help or harm a person, and the silence answered for him. I told you at the start there were 2 words the lawyer used to dodge it. There is one more exchange right after this where he reaches for them a final time. Watch how it went down.
No, you're speaking like a lawyer, okay? And I'm tired of, I've listened to you gentlemen, okay? Let's just get down to it. Mr. Chamberlain, tell me what Mr. Grime got right or wrong.
You got it all right. You think I'm really going to tell the guy who argued and won Callais that he didn't understand what he was arguing?
Okay.
Sorry, I'm totally respectful. Yeah, obviously. I think he's got a good handle on it.
I understand that, Mr. Cox, I don't mean to be rude, the importance of precedent and all that, but didn't the Supreme Court say, except in very narrow circumstances, you just can't use race to help a person, and you can't use race to harm a person, and that includes in drawing congressional districts?
In answering that question, I'm going to tell you that the Robinson Court, which gave rise to the district that was challenged in Callais, said that there was a violation of the Voting Rights Act, that it was required to draw a district or draw a redistricting plan that satisfied the Voting Rights Act, that allowed African Americans to elect candidates of choice.
You don't want to answer
that's
my
what
question,
was challenged.
do you, Mr. Cox?
I'm answering your question.
No, you're not.
Maybe an answer that you don't like, and my colleagues don't.
No, you're not.
But I'm answering
your
question.
You're giving us another lecture, and this is not a common law class. Tell me in simple terms, is that not what the court said?
The court said a lot of things that were inaccurate. So that court said you can't use race at all in drawing plans. We disagree with that. But what the court really did was say that you can prove race you can prove there's intentional discrimination, which is in violation of this Congress's intent. It also sprinkled partisanship as a defense for any challenge to any challenge under Section 2.
All right, well, I'm about out of time. I can see no disrespect, Mr. Cox, but you're not answering any of my questions. And I know you're disappointed in the decision, but let me put it another way. Do you think race should be used to help a person?
I don't understand that question. Race should be used to help a person?
Do you think race should be used to help a person?
I believe that if there is a racial violation of the law, that race discrimination, I believe a remedy that's race conscious can be required, yes.
Do you think race should be used to harm a person?
I don't really understand what that question
No, I didn't think you would. Mr. Chamberlain, do you think it's fair in America to use race to help a person at the expense of other races?
No.
Do you think it's fair in America to use race to hurt another person?
No.
How about you, Mr. Graham?
Absolutely not. Race should not be used to help or hurt an individual.
And no disrespect to Mr. Cox. He's very bright. I can see that. And I've been where you've been. You know, when you get in front of a court of appeal and you're losing, you know, you want to kind of obfuscate. I get it. But that to me is what the court's saying here in all these cases. We're not going to try to run your business. Not in the college admissions, not in drawn districts. But you can't use race. Period. End of discussion. And I think that's what the Constitution says and what most Americans support. I know you're disappointed, Mr. Cox.
I'm not disappointed. I'm outraged.
But that's what the Constitution says.